Hi, Bill Henshaw here again, your friendly local walking constitution out here in San Francisco, California. And another video I'm doing, this will be three in one day, that you'll learn a lot about, is an unlawful detainer action. And those on the surface look like they're really killers. They can just throw you in there, just about do anything and get you out on the street with hardly even a hearing and not anything in a judicial court like we have the right to. So I've got a big one coming up here the first of the week, where we're already kicking their ass. And they know it now. We just had a hearing, quote unquote, the other day in an administrative tribunal, which is all they have, not judicial courts. And that's why we beat them if we're in a sovereign, independent state admitted into this union. And right now, we're really taking it to a well-known local law firm who shall remain at the moment nameless anyway. And we got a quote unquote hearing apparently coming up on Monday. And yet we are just filing almost a 50-page motion to dismiss, saying that you bastards don't have jurisdiction and been you not one iota of it, no consent of the governed, and saying it with attitude and with authority. You can do the same in your situation. It doesn't matter where you are, because the bottom line is, even if they can prove that a quote unquote landlord-tenant relationship exists, and they can't get anywhere close to it in the case I have out here now with my sweetie, it's absolutely ridiculous. Even if it wouldn't be subject to any state judicial court, among other reasons, because the landlord-tenant agreement is executed in undefined dollars. We don't know what the hell these are. They're certainly not gold and silver coin. And the problem is they circulate and they're defined, if at all, by the president acting as commander-in-chief of the armed forces. You ever see that yellow fringe around the flag in their quote-unquote courtrooms? Ain't. That's why. So if he defines them, and that comes from a state of emergency, he's apparently allowed to unilaterally declare under the Income Tax Act of 1913, which doesn't exist, by the way, because at that time, just like now, no quorum to do business in either house and no ratio or representation in the House of Representatives. Doesn't exist. They don't want to go there. We will love to, especially in front of a jury that we'll almost certainly never see, because they're going to dismiss it. But that's a fact. So it circulates that way, and that state of emergency, by the way, and of course Roosevelt cited that good old FDR less than a week after the bastard got inaugurated. He cited that act, and more tellingly, he cited the Trading with the Enemy Act of 1917 with this bank emergency BS. At least that's a little truth in advertising, because that's what it is. We're in martial law rule, and they think we're undocumented enemy aliens, most particularly lawful de jure, jus sanguinis, free white state citizens. But it applies to everyone as far as they're concerned. They're colorblind. They don't give a rat's ass about any of us. The New York Bankers, 120 Broadway, New York, New York. That's what we have to take down, and better yet, take out. And we have an unprecedented window here to be able to do just that. It's exciting. First time in nearly 100 years, the U.S. Supreme Court is starting to act like an Article 3 judicial court. And there are good reasons for that I've discussed in past videos. I'm going to bring it up again and give you some of the inside scoop on what's going on there, to make this happen. And the Fifth Circuit Court of Appeals, now the most conservative court of appeals in the country, and even out here where I am, the Ninth Circuit is starting to act conservative too, because they're seeing all the bells and whistles go off here, and they know it's about time to start turning around and recognizing our rights, and especially the right to trial by jury, by the way, according to the course of the common law, where the jury can rule on the facts and the law, independent of the State Bar Association. That's the last thing they want to see, but we've had that right for over 800 years, going back to Magna Carta. We get that trial by jury back, we put them away in a hurry, and we just keep going right on down the road and do whatever we have to do to get each and every law off the books that they use against us. None of them are, by the way, because they simply don't have, for example, in in California, where I am, they have 80 members in the assembly. 80. Number hasn't changed since 1879 when that Constitution was ratified with a capital RAT. Racial representation then was around maybe 20,000 to 1, which is a very respectable number. With 40 million people in California, now the racial representation is 500,000 to 1. Do any of you out there think that's anything remotely related to a Republican form of government guaranteed to the states by Article 4, Section 4? And it isn't just mere numbers either. That makes a big difference because, just briefly, if we have that many districts out here in California and have the right number of people in the assembly, and that should be probably close to 700 or 800. Now we have much smaller electoral districts. People like you and me can run for office and not be beholden to the Democrats or the Republicans for campaign financing, which virtually does away with the two-party system. Ain't sayonara, see you later. And it just makes it much better in so many ways. And with that many people, and you get a ratio of relationship that they can relate to, and people want to go in there when they're not in session and talk to their representative and instruct them as we have the right to do. There's a much better opportunity to do that and correct them in any errors they may be making in what they think the law is or isn't, as the case may be. It's a big difference. It's not just the numbers involved. And here California's out here crying because the decennial population thing in 2020, they're going to go down from 53 to 52 in the House of Representatives, when what they should have with 40 million people is about 450 out of 1,500. That's the numbers that should be there, and it's more than a mere numbers game. But yeah, this is where we have a real opportunity to make a difference here and get things rolling in our favor. Excuse me just a sec. Yeah, and by the way, these unlawful detainers, to get back, I strayed a little bit here. But you get in that situation, contact me, uwinnincourt@gmail.com, particularly with a corporate landlord who doesn't even have standing in a judicial court. Not only do we have standing, we've got a right to be there from day one because we have protections. In Article 1, Section 9 or 10, as the case may be, U.S. Constitution, neither the feds nor the state can enact any bills of attainder, taking of life, liberty, or property without judicial process, i.e. trial by jury. And the landlord, being a corporate entity, isn't even registered to do business, in my case, in the state of California, where you're going to love this one. Send me an email, uwinnincourt@gmail.com for information. They can't even come into our judicial courts, and they can't compel us into theirs. Isn't that a nice touch? We have the power here, and we damn well should have it. We ordained and established this Constitution to secure the blessings of liberty to ourselves and our posterity. Not Chase Bank, not IBM, not Microsoft, to ourselves. We're the power here. The sooner we start acting like that and working together across the board, cut out all this divide and conquer BS they've been trying to do for 150 years, we all work together, we get the bastards off our backs. Thank you.